The DA Afriforum and Helen Suzman Foundation are challenging Jacob Zuma's medical parole. They want the parole reviewed and set aside. The application is being heard by the High Court in Pretoria today. Zuma was granted medical parole in September after being sentenced to 15 months imprisonment for contempt of court. eNCA's Barry Bateman is following the matter and joins us now. Barry, thank you for your time. We heard a bit earlier when we discussed, you and I, on the basis of the argument itself. What has taken place so far, again now, when you went back to court?
Well, what we've heard is the question of whether or not Arthur Fraser was in fact entitled to make this particular decision. And that's central to this because the Medical Parole Advisory Board had assessed all the relevant facts and made a decision, a determination that former President Jacob Zuma did not meet the requirements of Section 79 of the Correctional Services Act, which holds that he should either have a terminal illness or be incapacitated in such a way that he cannot be held in confinement and would need the various support. Arthur Fraser has submitted that no, he had the discretion to be able to make this decision. But to challenge that was Ishmael Jamie, the advocate for the DA, on these two aspects. Listen to these bites and take a listen to how they put this argument together.
And we assert and submit that the A requirement, terminal disease or physical incapacity, can only be decided and determined by a doctor, a medical practitioner. The functionary who acted in this matter, Mr. Fraser, who was the National Commissioner at the time, on the papers, not in dispute, is not a medical practitioner. He has no medical knowledge, expertise. He's not in a position to make that decision as to whether any particular inmate is suffering from a terminal disease or condition or is physically incapacitated in the manner required by the sections. The decision of the Medical Parole Board is to be found at para 20 of our heads, Justice, and it says not recommended based on the following. The Board appreciates the assistance from all specialists with provision of the requested reports. They had all the reports. The Board also notes and appreciates the use of aliases and has treated all submitted reports as those pertaining to the applicant. From the information received, the applicant suffers from multiple comorbidities. His treatment has been optimized and all conditions have been brought under control. From the available information in the reports, the conclusion reached by the board is that the applicant is stable and does not qualify for medical parole according to the Act. That was a final, definitive conclusion with all the facts at its disposal.
Now, very interesting, Barry, what the council is saying there, because we're under the impression that he did in fact undergo some sort of medical checkup. Do we remember when was this and what exactly happened?
Yeah, you're quite right. And it's standard procedure. When any person is admitted to a correctional facility, they would undergo an admission health check. And this would be to determine whether or not they have any underlying issues and so on, to determine what care they would get while they are incarcerated. Former President Jacob Zuma also underwent this very check. And this is important to the understanding of whether or not the former president was entitled to be granted medical parole. Because upon his admission, there was nothing that was found that is consistent with the requirements of that Section 79 of the Act. Take a listen to this argument by Jamie.
Mr. Zuma would have, upon his admission to Escort Correctional Facility, have undergone a health status examination. What is significant, Justice, is the papers are silent on any, in fact, don't suggest at all, the answering affidavits and the documents put up as part of the redacted record do not suggest that any life-threatening condition was detected on the 8th of July when Mr. Zuma was admitted. But suddenly, we know from the papers, the Commission's affidavit says on the 23rd of July, Mr. Zuma's condition began deteriorating, and then there were a series of medical reports and interventions. You, with respect, can take judicial cognizance of the fact that Mr. Zuma is on the public stage just before his admission to prison. He conducted a very well-publicized press conference at his home in Nkandla without a mask, flanked by his legal representatives. He was in a, if I may say, a combative mood. He was defiant of the Constitutional Court to the end. There was absolutely and is absolutely no indication that he is physically incapacitated as required by 79(1)A. After his release on medical parole, again well publicized, he visited a casino in Durban justice in order to meet political allies. Absolutely, he was seen leaving his vehicle, going into the casino, coming out with files under his arm, etc. Absolutely no indication of physical incapacity.
You know, Barry, the argument that this council makes is one that speaks to being physically incapacitated, because I know I've heard the foundation stating that that is myopic, to think that the only people who are granted medical parole must be ones who are physically incapacitated and at death's door. I mean, that's what at least the court will perhaps clarify for some of us as to when are you eligible for medical parole, for those that didn't know. But beyond this, what is the Helen Suzman Foundation proposing would be the correct remedy in this instance, because he is in fact now eligible for normal parole?
You're quite right, and that was an issue that Matajane J raised earlier when dealing with the DA. What do you propose then should be the outcome? Should this be remitted back to the parole board, given that he is eligible now for parole? Well, the submission from the DA through Jamie was essentially that, and he didn't go quite into the detail, but the net effect of it would be that Zuma should go back to jail, and there should be a fresh application for the normal parole, because as it stands, no such exists. Now, the Helen Suzman Foundation went straight to the point. That is exactly what they want. They want Zuma to go back to jail, and they want to even go further. They want this time that he's on medical parole not to count towards his sentence. Take a listen to Advocate Max du Plessis.
The HSF further asked, my Lord, for an order that Mr. Zuma's time on medical parole shouldn't count towards fulfillment of his sentence. This is the just and equitable relief required to give full and proper effect to the corrective principle, my Lord, and the Constitutional Court's contempt judgment. The Constitutional Court made it clear that never before had there been such a challenge, such a threat to our rule of law and democracy and the Constitutional Court than the conduct of Mr. Zuma. It said that the only sentence that could possibly be just and equitable was 15 months imprisonment. And hence that answers the question, my Lord, of what a just and equitable order is in this case. That is that Mr. Zuma must be returned to prison to serve that 15-month period.
Barry, this case has in fact gripped the nation. It will be interesting to hear how it unfolds. Thank you very much. That's reporter Barry Bateman talking to us on that case. Now, still to